Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to talk about registering a out-of-state judgment or a court order here in Connecticut. The most common reason you would want to do this is if a court order entered in another state and then neither party is living in that state anymore. So if you want to enforce or modify the existing court orders, and you don't want to go back to that original state, or you might not be able to go back to that original state because nobody's living there anymore, what you're going to want to do is register the order here in Connecticut, and then you can do what you need to do, whether it's filing a motion for contempt if you want to have the order enforced, or filing a motion to modify if you're trying to seek a modification to the order. You would first need to register it here in Connecticut. So let me first highlight the relevant statutes, which I've just shared my screen. So let's start with filing so I'm going to talk about filing a foreign matrimonial judgment. So if it was a divorce, and then I'm going to talk about filing a foreign custody order if there's a order in another state between two parties who were never married. So the filing of a foreign matrimonial judgment or divorce judgment is dictated by 46B-71, and it states that any party to an action in which a foreign matrimonial judgment has been rendered shall file with a certified copy of the foreign matrimonial judgment in the court in this state in which enforcement of such judgment is sought, a certification that such judgment is final, has not been modified, altered, amended, set aside, or vacated, and that the enforcement of such judgment has not been stayed or suspended, and such certificate shall set forth the full name and last known address of the other party to such judgment, and the name and address of the court in the foreign state which rendered such judgment. Then goes on to say that such foreign matrimonial judgment shall become a judgment of the court of this state where it is filed, and shall be enforced and otherwise treated in the same manner as a judgment of a court in this state, provided such foreign matrimonial judgment does not contravene the public policy of the state of Connecticut. And that rarely happens, that a foreign order is against the public policy of Connecticut. The statute goes on to say that a foreign matrimonial judgment so filed shall have the same effect and may be enforced or satisfied in the same manner as any like judgment of a court of this state, and is subject to the same procedures for modifying, altering, amending, vacating, setting aside, staying, or suspending such judgment as a judgment of a court of this state, provided in modifying, altering, amending, setting aside, vacating, staying, or suspending any such foreign matrimonial judgment in this state, the substantive law of the foreign jurisdiction shall be controlling. So what that last part means is that, let's say you have a child support order that enters as part of your divorce agreement in Michigan, and then the parties are no longer living in Michigan. One party who has the child is living here in Connecticut. You register the foreign order here in Connecticut and file a motion to modify the child support order. In determining the Connecticut child support order, they're going to apply the substantive law of Michigan. So they apply the child support laws of Michigan in determining what the new Connecticut child support order would be. So that's the relevant statute that deals with registering a foreign divorce judgment. And then if it's a child custody determination, the relevant statute is 46B-115W. I'm just going to highlight the relevant parts that kind of talk about the procedure on how you register an out-of-state judgment. So the first part says that a child custody determination issued by a court of another state may be registered in this state with or without a simultaneous request for enforcement by sending to the Superior Court in this state, 1, a letter or other document requesting registration, 2, 2 copies, including 1 certified copy of the determination sought to be registered, and a statement under penalty of perjury that, to the best of the knowledge and belief of the petitioner, the order has not been modified. And 3, except as otherwise provided in, in a different section, the name and address of the petitioner and any parent or person acting as parent who has been awarded custody or visitation in the child custody determination sought to be registered. So basically, you just have to put the name and address of both parties. That's what that last part means. And then within 5 days after the registering court's receipt of the documents required by subsection A, which is what I just went over, the petitioner shall notify the persons named pursuant to subdivision 3. Basically, you have to provide notice. Shall notify the person of this section of the registration of documents by certified mail, return receipt requested at their respective last known address, or by personal service, and provide them with an opportunity to contest the registration in accordance with this section. So basically, within 5 days of registering the foreign judgment in Connecticut, you have to provide notice to the other party, either by certified mail or by serving them with a marshal or process server, or whoever effectuates service pursuant to the laws of that state. The notice required in this subsection shall state: 1, a registered determination is enforceable as of the date of the registration in the same manner as a determination issued by a court of this state. That's to say, 2, a hearing to contest the validity of the registered determination must be requested within 20 days after service of notice. And 3, failure to contest the registration will, upon proof of notice, result in confirmation of the child custody determination and preclude further contest of that determination with respect to any matter that could have been asserted. So that's the relevant statute that applies to registering a foreign child custody determination. So let me show you. I'm not going to show any samples on registering an out-of-state divorce agreement, but I will show a sample on an registering an out-of-state custody order. So the first document you're going to need is a motion for registration of foreign orders of custody and child support, or just custody if there's no child support. So you just put that pursuant to section 46B-115W, which is the statute I just showed you. The plaintiff in the above captioned matter respectfully moves this court for registration of the following foreign orders. Put that the parties were unmarried and have one minor child. Insert that child's name and date of birth. Indicate that orders of custody were ordered by the court of, insert the court's name of wherever that state is. And in an action, include the case title and the docket number. You're going to include that you have a certified copy of the final judgment is attached. And again, you need the certified copy and then one copy of that certified copy. So 2 copies total. You have to indicate that the undersigned certifies that the final judgment is final, has not been modified, altered, amended, set aside, or vacated, and that the enforcement of such order has not been stayed or suspended. Include the names of both parties, the name and address of the court where the order was entered. And then below that, you have to include an affidavit of the either plaintiff or defendant, the affidavit of the person who is registering the judgment here in Connecticut, basically saying that it was a final custody order, include where it was entered, and the fact that the existing orders have not been modified. So you're going to file with the Connecticut court. You're going to file that motion for registration along with the affidavit of the person who is seeking to register it in Connecticut, and include the 2 copies of the existing orders, one of which are certified. So you're going to register those, or you're going to file those with the court. And then after they are filed, you have to, again, pursuant to that statute, provide notice to the other party. So this is the notice form that basically says notice of registration of foreign judgment. And you're going to say that pursuant to the statute that we just went over, the plaintiff in the above captioned matter notifies the defendant that on so-and-so a date, the final judgment entered by the court of, and then insert the court of the original state and the date that the order went into place. So you're going to put all that info in, and you're providing notice that it was registered in Connecticut, and then you're just going to put the court where it was registered. This example, I use New Haven. Obviously, it can be anywhere in Connecticut. And then you're just going to include the standard language that pursuant to the section, the registered determination is enforceable as of the date of registration. A hearing to contest the validity of the registered determination must be requested within 20 days after receipt of service, and that failure to contest the registration will, upon proof of notice, result in confirmation of the child custody determination and preclude further contest of that determination with respect to any matter that could have been asserted. So basically, so you're going to file that notice, or you're going to serve that notice either by certified mail or, a process server, marshal, whatever the appropriate person is in the state where the other party lives. So you're going to provide them with notice, and then you're going to file with the court a copy of this notice along with a return of service that shows proof of service. And then 20 days later, then the person receiving notice has 20 days to contest the determination. So you can, once all this stuff is filed, you can then file a motion for contempt or a motion to modify the existing court orders, or do whatever you need to do following the registration here in Connecticut. So those are the basics, and it includes a sample motion. If you want access to those documents, you can visit our website at dolanfamilylaw.com and you can get copies. And if you have any questions, as always, you can feel free to give our office a call and speak with one of our attorneys.